Welcome back, folks. My name is Wyatt. I'm the College Conservative, and welcome to the 5th episode of the College Conservative. Now, I'm going to today continue on why independent regulatory commissions are unconstitutional, and hopefully just this 3-episode little mini-series of showing you as to why independent regulatory commissions are constitutional, really the history behind it, and then obviously today how the government has way overstepped its boundaries with them and why they're just totally crappy. So last episode, I just want to restate real quick that I talked about the 1624 English Statute of Monopolies, which took away the general patenting power away from the crown and away from the government of England, and made it so anyone, not just the crown's buddies or not just who the crown picked, but anyone could go and get a business license and open up their own business to further help spread competition into the English market. And this was all part of an English free market revolution, if you will. Anyways, I also talked about the general patenting power and how patent was not even put anywhere into the Constitution, and that's because of what a patent is, and a patent and its definition is just an economic privilege, or even economic grant or economic privilege through the government. And then I talked about how the founders, knowing this, only gave the federal government specific power delegation when it came to the economy through the patent clause, and through the commerce clause, and then through also another article that I'm going to go through in this talk. So I want to start off. I want to talk about the commerce clause. I want to read it off real quick. So the commerce clause states that the United States Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Now, as you can see, it says to regulate commerce among the several states. And really, to help reinforce what it's trying to say here, I want to as well go to Article 1, Section 10, Clause 3 of the Constitution, which states, "No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state or with a foreign power," and then it continues a little more. So the two most important parts here for what I'm speaking of is going to be no state shall without the consent of commerce, and then go towards the middle, enter into any agreement or compact with another state. So here in these two, so in the Commerce Clause and in Article 1, Section 10, Clause 3, the Constitution is giving the federal government specific and only these powers when it comes to economic privileges or economic rights, meaning they only have the power to watch over compacts that are created between the states, because the states are allowed to create trade compacts and commerce compacts, but the federal government has the right, in order to inhibit monopolization, in order to help competition flourish and free trade flourish between the states. The federal government has the right to oversee these compacts or to superintend these compacts. And then this thus goes once again to what I was speaking of last video, the General Welfare Clause, and how a lot of people, and especially those on the left, tried to say the General Welfare Clause was a broad, basically power delegation to the federal government from the founding fathers and from the Constitution, which it was not in any way, shape, or form because of its grammar that it was used in expressing the clause, and its punctuation and what else. Anyways, so this really goes to show how the General Welfare Clause in the Constitution was not there to give the federal government the power to basically act upon whatever it wanted to, whenever it wanted to, in the name of the public good. Not in any way, shape, or form. And actually, Madison speaks about this in Federalist Papers 42. And he speaks about this whole topic in Federalist Papers 41 through 43, but in 42 specifically, he speaks about how it would have been absolutely in conflict with each other, the notion of the General Welfare Clause, and then the specific power grants to the federal government, which were really modicum in nature, because they didn't want the federal government having any incorporation powers and monopolization powers, or these broad economic powers over the states and over the people and over the market. And actually, Madison speaks about this. When he speaks about this, he says, "For what purpose could the enumeration of particular powers be inserted, if these and all others were meant to be included in the preceding general power. Nothing is more natural or more common than first to use a general phrase and to explain and qualify it by enumeration of the particular powers. But the idea of an enumeration of particulars, which neither explain nor qualify the general meaning, and can have no other effect than to confound and mislead, is an absurdity. So what he's saying here, he's saying exactly what I'm saying. And he continues to say, what would have been thought of that assembly if, attaching themselves to these general expressions disregarding the specifications which limit their import, okay, they had exercised an unlimited power providing for the general welfare. He ends up in a question mark. What he's saying is, what would be the whole point of putting these specific powers delegated, and these very small specific powers delegated to the federal government in the Commerce Clause and the Patent Clause and other clauses? What would be the point of putting those if we're just going to now give the government the power to do what it feels like it should do for the public good, and for the public general welfare in the general welfare clause in the preamble? There would be absolutely no point, and they would just be a waste of time, is what he's trying to say. Unfortunately, this has obviously been way manipulated and taken advantage of by those on the left. To continue real quick, so Madison also gave out 6 different principles of the federal government, the 6 responsibilities of the federal government, and I'm gonna read them off one more time and go through just 1 or 2 of them real quick. The most important one. So the first was security against foreign danger, regulation of the intercourse with foreign nations, maintenance of the harmony and proper intercourse among the states, certain miscellaneous objects of general utility, restraint of the states from certain injurious acts, provisions for giving due efficacy to all of these powers. So basically, in the third one, what Madison is saying, in maintenance of the harmony and proper intercourse among the states, really, and through the Commerce Clause, this is basically saying what the states cannot do. Now, having said that, that does not mean that what the states cannot do, the federal government can do. As we can see in the 10th Amendment, in the Constitution, it says, whatever powers that are not delegated specifically to the federal government, and it is a very small amount of specific actions, are thus delegated to the states or to the people. And just a story continue, and I spoke about Justice Joseph Story, who was a nationalist. I spoke about him in my previous episode, which means he wanted a bigger federal government. And even though he wanted a bigger federal government, he did not mean it in the sense of today's liberal or Democrat. He meant that in the sense of he felt that the federal government should have a little more power when it came to having oversight or control over a little more things. He was still, by today, pretty conservative in his thought of the federal government and its powers, by today's standard at least. And so he comments and just says that the federal government and the Commerce has the power to superintend commerce among the states, which means to restrain certain laws that the states can pass that would cause monopolization within them. So the Commerce Clause really is just there to basically give government the authority to prevent states from passing laws that would cause monopolization or monopolies or oligopolies and thus negatively affect commerce within other states. So, for example, if in the state of Illinois, right, if they taxed milk being sold in their stores higher, that was produced in Wisconsin, let's say, higher than milk that was produced in their own state in stores, now that could be called for concern, and that could really inadvertently be a way to help monopolize a certain business, whether due to government collusion or whatever else. And a lot of times these laws are based off of collusion in general, which is why the state and federal government needs to be smaller, period, in my opinion. Anyways, or if it were to say that even milk from Wisconsin is not allowed to be sold in the state. Or if he would even say that. Or milk from any other state is not allowed to be sold except for inside the state of Illinois, which would obviously create oligopoly and monopoly and hurt consumers and hurt the economy there and would inhibit competition. And the federal government would have the absolute right to come in and say, no, this inhibits commerce, and this is because it hurts commerce among the states, not because of necessarily what it does within that state, because that state can pass its own certain laws here and there depending on how that affects commerce, but this will affect commerce to the point where it will cause monopoly and oligopoly and negatively affect the commerce with states around it. And then real quick, I want to go to a case whose adjudication really supports this claim and shows the Commerce Clause being put into action correctly, which is Gibbons v. Ogden. Now, Gibbons v. Ogden has been manipulated because the federal government stepped in and said that we have the sole right of navigation, of regulating navigation within the country. So what happened was these two gentlemen, who their names are irrelevant, but these two gentlemen were basically given the sole power from the state of New York to license out the ability for people to run ferries and steamboats and whatever else through the waters of New York. Now, what happened was the governor of New Jersey, who was Ogden, tried to fight this at first, realized that he couldn't win, then submitted to him, and got a license through the two gentlemen, who had the sole right via New York law to give out licensures to people to run ferries through New York. So what ended up happening was Ogden goes in business with Gibbons. Gibbons actually ends up getting his own. Gibbons ends up giving his operating another steamboat, which is given to him and was legally given to him through a law that was passed in 1793, which regulates coastal trade, and was given to him through the federal government. So what happened was Ogden's got frustrated with this, brought him to court, got the court to give him Gibbons an injunction, which made him stop running ferries. So what happened was Gibbons brought it to the Supreme Court, and the Supreme Court adjudicated that the federal government has the sole right to regulate the navigation of waters, and that it was unconstitutional, and that it was an overreach of state power. And not only that, but that the state of New York was causing a monopoly by just giving these two gentlemen, the sole right to now offer out licensures, which means that you, through New York law, you had to go to these two gentlemen and pay them in order to apply for a license to run a ferry through New York. And the federal government said, no, you're not allowed to do that in New York because that causes a monopoly, and that can cause oligopoly, and that inhibits commerce between these two states, specifically here between New Jersey and New York. However, the two gentlemen started to bring their monopoly elsewhere down the East Coast. And the federal government nowadays has way taken advantage of this, and the left has taken advantage of this case, and saying that, well, look, the federal government is allowed to step into the economic affairs of the states. No, it's not. It's just supposed to be there to regulate commerce among the states, so that the states don't create pacts, or that the states themselves don't create laws within them that will create a monopoly and inhibit commerce negatively, amongst the states. That's the point of the Commerce Clause. It was really just to help within the checks and balances of the states have sovereign power, and the states actually have the general patent power to a certain point. That just a story also speaks about, and Madison also speaks about. The states actually have the general patenting power, which I spoke of in the last video, if the people so choose to give it that. And it's only to a modicum. It's not all the way like, you can have just totalitarianism in every single state. Nothing like that at all. Because that would go against the constitutional rights of the people as well when it gets too big and too expansive. Anyways, folks, I hope y'all learned something. We all learned something about the Commerce Clause, about the actual meaning of the Commerce Clause, which was really just specific power delegation given to the people, given to the federal government to stop monopolization and stop laws that cause monopoly. Stop laws passed by states that would cause monopoly within those states, and thus negatively hurt commerce amongst the states. But states are allowed to enter their own economic compacts so long as it helps competition flourish. Thank you so much, folks, for tuning in. I'm going to continue this in one more video next time. Hopefully I'll have it up tomorrow if I can. My name is Wyatt, and I am the College Conservative.